All right, we will call the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Harris, Senator Orenshaw, Senator Don Darrell Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you so much. We have everybody present, which is why we will start with our work session. Just a couple of housekeeping matters before we get there. Number one, I just want to publicly thank our staff for working tirelessly. Yeah, they deserve a round of applause, honestly. If there are any errors as we move through today, it is not their fault, and any delays are not their fault. I have been emailing them amendments and requests and additional bills up until the moment even since I've walked in this room, I've given them more stuff to do. So I just want you guys to know how much I appreciate you working with me and making my job as easy as possible as I continue to make yours as hard as possible. And so with that, we do have a longer work session today. We've tried very hard to get all of the proper amendments uploaded to Nellis and also let everybody know who has a bill on work session. So if there are any questions, we might call you up to the table to answer them, explain things, make sure we have the right stuff that we need. And the other thing that I did want to mention is that as far as I'm concerned, any member here who votes one way in committee always has the right to change their vote on the floor. I'm not saying that you don't have to, you're not allowed to tell us that you're reserving your right or anything like that. I appreciate if you want to get that on the record, but I don't want anybody to think that if a member votes one way here and votes a different way on the floor, that that is somehow not allowed or that I will be mad at them, or I've heard things like this over the past few days. So I just want to make that clear that everybody always has the right to change their vote. And so I think that's all the housekeeping. We're going to do the work session first, then we will do the two bill hearings, and then depending on who we have, if of our committee, we might have to recess and come back to work session those last two bills that we just heard. And with that, I think I'm ready to launch into our marathon work session, starting with SB 14, and I will hand it over to Mr. Guinan to walk us through the work session document.
Thanks, Chair. For the record, Patrick Guinan, Committee Policy Analyst. As the Chair mentioned, we're going to start with SB 14. This is a bill relating to gaming. It's a judiciary bill that was brought on behalf of the Gaming Control Board, and we heard it here on Valentine's Day. So I'm going to go through it because it's been quite a while since the committee has heard it. Senate Bill 14 authorizes the Nevada Gaming Commission to adopt regulations allowing the chair of the Gaming Control Board to approve persons associated with a deceased licensee or a licensee who has been judicially declared disabled to temporarily engage in gaming activities without procuring a gaming license for such time as the chair deems necessary to settle the estate of the licensee. The bill also authorizes the Gaming Control Board to designate as bad debt any amount of debt it assigned to the state controller that the board determines is impossible or impractical to collect. If the state controller determines that it is impossible or impractical to collect the debt assigned by the board, the controller must request that the Board of Examiners designate the debt as bad debt. The bill provides that any judicial review or judicial determination of the board decision can be made only in the First Judicial District Court in Carson City. Any person authorized to receive a share of revenue from any slot machine operated on the premises of a licensee is liable to the licensee for a proportionate share of the license fee and is required to remit or credit the proportionate share to the licensee by a date certain. And finally, the bill provides that members of the Gaming Commission may elect not to participate in the public employees retirement system. There is a pretty extensive amendment that is submitted by the board, and I'll just run through the bullet points of it very quickly. The amendment allows the chair of the board sole discretion regarding whether to administratively approve certain persons to temporarily engage in gaming activities without a license. It adds the ability to limit such administrative approvals. It clarifies that a person who has been granted such approval and who receives proceeds from gaming must comply with Chapter 463 of NRS and related regulations and is subject to disciplinary actions for noncompliance. It revises the definition of gaming employee. It modernizes statutes regarding the oversight of cloud service providers related to interactive gaming. excuse me, it revises the components involved in the operation of a race book or a sports pool. It restores language allowing judicial review of a commission decision or order to take place where the petitioner resides or does business, and it allows the governor to appoint a retired employee as a gaming commissioner under emergency conditions. And that's the full amendment, Chair.
Thank you very much. Are there any questions on the bill or the amendments? Or the sponsors want to add anything at this time? Not seeing any. I would accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen, a second from Senator Orenshaw. Any discussion on the motion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. It is a unanimous vote to amend and do pass. Do I have a volunteer for the floor statement? All right, Senator Orenshaw. That brings us to SB 35, I think.
All right, we're now at SB 35. This is a bill sponsored by the Committee on Health and Human Services. We heard it here on April 10th. Senate Bill 35 establishes the crime of low-level trafficking in fentanyl, mid-level trafficking in fentanyl, and high-level trafficking in fentanyl. It establishes these crimes of trafficking, and anyone who knowingly or intentionally sells, manufactures, delivers, or brings into this state, or is knowingly or intentionally in actual or constructive possession of fentanyl is guilty of 1, a low-level trafficking fentanyl is a Category B felony if the quantity is more than 4 grams and less than 14 grams. Second, mid-level trafficking in fentanyl is a Category B felony if the quantity is 14 grams or more but less than 28 grams. And 3, high-level trafficking in fentanyl is a Category A felony if the quantity is 28 grams or more. And all of those are subject to certain prescribed penalties. The committee will remember that Attorney General Ford and Majority Leader Cannizzaro presented this bill with Senate Bill 343 as their complementary bills, and they're being amended in a complementary fashion. The amendment that General Ford offered on SB 35 at the initial hearing is attached. That amendment removes the low-level trafficking provisions from Section 1 of the bill. It adds clarifying language that relevant provisions of the bill apply to illicit fentanyl derivatives and mixtures, and adds new language providing for the implementation of medication-assisted treatment programs in jails and prisons to the extent that funds are available. That's all, Chair.
All right. Any questions on the bill or the amendments? All right. Not seeing any, I would accept a motion to amend and do pass. Okay, we have a motion from Senator Krasner. We have a second from Senator Nguyen. Any discussion on the motion? All right. Oh, I'm sorry. Vice Chair Harris.
Thank you, Chair Scheibel. I will support the bill out of committee today, but would like to reserve my right.
Understood. Senator Orenshaw.
Thank you, Chair Scheibel. I appreciate General Ford, Majority Leader Cannizzaro's work on these bills. I also am going to support today, but reserve my right to change on the floor.
Understood. Any further discussion? Seeing none, all in favor, aye. Aye. Any opposed, nay. Vote is unanimous to amend and do pass. And I will assign the floor statement to the Majority Leader.
Okay, Senate Bill 38 is up next. This is a bill, a committee bill brought on behalf of the Attorney General. It was heard here on March 2nd, and it revises provisions relating to offenses against children. This is a luring bill, essentially. Senate Bill 38 defines a person in position of authority for the purposes of the bill to mean a person 18 years of age or older who is or was an employee or volunteer at a public or private school and who by reason of his or her position can exercise significant or undue influence over a pupil. Such a person is guilty of a Category C felony for contacting a pupil under the age of 18 for the purposes of either luring the pupil to certain locations without parental or guardian consent and with the intent of avoiding such consent, or for contacting a pupil with the intent of having the pupil engage in sexual conduct either in person or remotely, having the pupil distribute a sexual image of themselves to the person, or having the pupil engage in the commission of a crime. Such a person is guilty of a gross misdemeanor for encouraging a pupil to engage in behavior that would cause the pupil to become a child in need of supervision or a delinquent child. The bill makes penalties applicable to other sexual assault violations, applicable also to these violations, and similarly prohibits victims or witnesses of these violations from being ordered to submit to psychological or psychiatric examinations. Violations of Certain of these provisions are also added to the list of sexual violations that require lifetime supervision. The bill adds these violations to those for which certain education-related licenses may be suspended or revoked, and provides that a person convicted of these violations forfeits rights of employment after the arrest. There is an amendment submitted by the the Nevada District Attorneys Association, and it's attached for review. That amendment revises Section 2 of the bill as follows. Strikes language relating to consent of a parent or guardian and inserts language indicating that, quote, the person in a position of authority, end quote, instead acted for the purpose of engaging in or facilitating the commission of a felony or the commission of a felony or gross misdemeanor as appropriate. It clarifies that a person has not violated the bill's provisions if they received, there's a typo here, if they receive an unsolicited sexual image or communication and the person reports that to the proper authority immediately, and it revises slightly the definition of person in a position of authority and sexual conduct for the purposes of the bill.
All right. All right. Any questions about the bill or the amendments? All right. I'm not seeing any questions, so I would accept a motion to amend and do pass. All right. We have a motion from Senator Nguyen and a second from Vice Chair Harris. Is there any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. It is a unanimous vote to amend and do pass Senate Bill 38. Is there a volunteer for the floor statement? I will assign it to myself.
Excuse me. All right, we are now at Senate Bill 61, which involves relates to crimes involving the deposits or proceeds of an account held in joint tenancy. This is a bill brought on behalf of the Nevada Supreme Court. It's a committee bill. We heard it here on March 6th. SB 61 provides that the mere fact that an account is held jointly does not, in and of itself, preclude a person whose name is on the account from being prosecuted for a crime involving theft from any deposits or proceeds of the account. These provisions also apply to an account held jointly by an older person or vulnerable person, such that holding an account jointly does not convey legal ownership of the account in any way that would preclude a person from committing exploitation of an older person or a vulnerable person. The Attorney General has proposed an amendment that is attached on the following page. It revises Section 5 of the bill to specifically reference accounts of older persons and vulnerable persons in accordance with statute.
All right. Any questions on the bill or the amendment? Senator Krasner.
Oh, thank you, Chair. I was wondering if I could ask a question of Ms. Woodrum, please.
Yes. She is here.
She was the presenter of the bill. Thank
But she
you
was
very
hiding.
much.
You thought you would get out of this.
Good afternoon, Madam Chair, members of the committee. Homa Woodrum for the record. Happy to answer any questions.
Thank you very much. I appreciate that. So this bill applies to an account held jointly with an older person. My only concern is that, this body often says, nobody can just decide who can marry who or who can love who, regardless of the color of their skin or their gender. But I want to make sure that we're not saying that because of their age, if a man is 25 years older than his wife and says, oh, honey, I can't get around, but, at the holidays, I know you love jewelry, go buy yourself a $10,000 diamond necklace. And then the next year says, go buy yourself a nice Rolex watch. And then he dies. Are the stepchildren then going to be able to bring some case that say, oh, look at these expenditures this woman made year after year? I just want to make sure that married couples are exempted from this. Thank you.
Homa Woodrum for the record, through you, Madam Chair, to Senator
Please go
Krasner.
direct.
Oh, thank you. First, I would want to address your hypothetical relating to, for example, stepchildren trying to bring a case. This relates to Chapter 200 relating to criminal matters, so the stepchildren couldn't bring, for example, a civil case based on this, but also to clarify that this is not meant to intrude upon community property or to create some new avenue in this situation related to married individuals. In prior cases that we have had related to allegations that you would describe, the only way that we've ever been able to address them is if we were in a situation where the marriage itself was a fraud and we were trying to annul the marriage first so that we could then address whether that conduct was appropriate. But it is not meant in any way to create some kind of crime between May-December romances or to intrude on their private decisions to provide gifts. This is just about whether we could investigate crimes of exploitation where someone is completely wiped out of their funds and unable to take care of themselves, so it would not create any kind of cause of action in the scenario you described.
And follow up, please. And I appreciate you saying that there would be no grounds for a civil action. What about criminal action? And then what if, they later end up getting a divorce or in the middle of a divorce proceedings, and the man who's 25 years older can't really even remember that he gave her permission and told her, every year at the holidays, I want you to go buy yourself some nice jewelry. And now is she going to be suddenly suspect of doing something wrong?
Homa Woodrum, for the record, thank you for the question. It would not subject them to a criminal action in that situation if the facts didn't support the core elements of exploitation in NRS 200, which are highly specific. So it would not create a situation where someone doesn't remember that they gifted something and then would have to prove it otherwise. I will say for the record that our office is still in discussion with the public defender representatives to possibly maybe provide some more clarification as to those types of concerns on the assembly side, if we're able to, spend a little more time fine-tuning some language to deal with the concerns that were expressed during the first hearing on this bill, and obviously the concerns you're sharing now. So again, it's not our intention to do that, and we'd love to work together to craft language that would kind of mollify those concerns. So we have no problem with that.
I appreciate that. Thank you.
All right, thank you. Are there any other questions? All right, we have a motion from Senator Stone to amend and do pass. Is there a second? Second from Senator Wynn. Any discussion on the motion? I'll just add that, I had some concerns at the initial hearing. This amendment does allay those concerns. I think we're all on the same page about wanting to protect people from actual victimization and not cast too wide a net that we pull people in who are, behaving in non-criminal ways. So if there is more fine-tuning to be done, happy to help if we can. Otherwise, I'm ready to take a vote on the motion to amend and do pass. All in favor say aye. Aye. Any opposed, nay? All right, we have one nay from Senator Krasner. The rest are ayes, and the motion carries to amend and do pass. Do we have a volunteer for the floor statement? All right, Senator Wynn.
Okay. We're now at Senate Bill 104, which was sponsored by the Committee on Growth and Infrastructure based on a recommendation from the Interim Judiciary Committee. Senate Bill 104 relates to traffic offenses, and we heard it here on the 22nd of February. The bill removes the court's authority to suspend a person's driver's license or prohibit a person from applying for a driver's license due to a delinquent fine, assessment, or fee associated with a civil penalty imposed for a traffic violation. A person subject to such a suspension or delay when this bill takes effect is to have their license or ability to apply for a license reinstated by the Department of Motor Vehicles at no cost and be notified of such, nor is such a person to be required to undergo a physical or mental examination to have a driver's license reinstated. There is an amendment provided by the committee to the bill that is attached, and I'll go through the bullet points of what that amendment contains right now. The amendment revises the required content of traffic and civil infraction citations. It authorizes a peace officer to request the email address and mobile phone number of a person who receives a citation, requires a court notice concerning a civil infraction to include information on any online dispute resolution program that the court has established, requires a court or traffic violation bureau system for handling citations to allow the input of the registration number of a vehicle that a person was driving when the infraction occurred. It requires a person to respond to a citation within 90 days of issuance or court filing, whichever is later. It allows a person to request that the fee associated with a citation be waived or that they be allowed to enter into a payment plan, and authorizes a court to do either. It provides that fees for civil infractions are to be paid to the city or county treasurer as applicable where the infraction was filed. It revises the timeline for a prosecutor to elect to treat a misdemeanor as a civil infraction and makes other procedural revisions accordingly. It authorizes a district attorney to allow a traffic enforcement agency to elect to have certain misdemeanor offenses be civil infractions. It allows a peace officer to arrest a person for certain civil violations without a warrant. It provides a prosecutor immunity from liability for prosecuting civil infractions in the same manner as is provided for prosecuting violations of criminal law. And it allows a Board of County Commissioners to provide by ordinance that certain violations of traffic ordinances may be treated as civil infractions rather than criminal violations. It also requires the Department of Public Safety, in consultation with other traffic law-related entities, to conduct a study of how best to develop and implement a standardized statewide civil infraction citation system and submit its findings and recommendations to the Joint Interim Standing Committee on Judiciary. And finally, it requires justice and municipal courts to adopt rules governing setting aside a default judgment in an action relating to a civil infraction by January 1 of 2024.
Thank you. Questions on the,
Madam Chair, could you have Patrick repeat that, please?
any questions on the bill or the amendment? Did you want to, yeah, go ahead, Senator Wynn.
Thank you. I just wanted to thank everyone that has participated in this. I know that there is implementation problems and issues, but I do want to point out that there are some amazing players that have participated in what the implementation problems are looking like and have been a part of that process since this bill passed in 2021. On the flip side, there are other jurisdictions, mostly in southern Nevada, that have not participated, have not enacted the clear intent of most of this legislation from 2021 that passed in an overwhelming bipartisan manner. And so I hope that they will continue to come to the table. I know that because this was implemented in January of this year, there are many jurisdictions. I know the city of Henderson, the city of Las Vegas, and other jurisdictions throughout the state have not quite had some of the same problems as one of our major jurisdictions in the Las Vegas Justice Court. And so hopefully they will learn from their partners within the state how to do this and how to implement this correctly, to give the most, to cut back on their backlog and clearly follow the intent. But if we do need to continue to make those corrections to make this more implementable or to make our intent abundantly clear, if it wasn't in all of these bills that passed in 2021, I will continue to work on that. I know that there's some things that I've been working on to make sure that it continues. So unfortunately, while this is in a very good place right now, and this makes a lot of corrections that Las Vegas and Metropolitan Police need, that the jurisdictions that have thoroughly participated in working groups over the past 18 months on this, I think there will probably be some more. And so I just appreciate everyone's support and working through this.
Thanks. Thank you, Senator Wynn, and we also appreciate you working so hard on this because I know that it has not been easy and it has been a lot of time and effort on your part to help us, achieve the vision that we all had for decriminalizing traffic citations in Nevada. Are there other questions on the bill or the amendment? All right, seeing none, I would accept a motion to amend and do pass. We have a motion from Senator Orenshaw, and I think that was a second from Senator Stone. Any discussion on the motion? Not seeing any. All those in favor say aye. Aye. Any opposed, nay. We have another unanimous motion to amend and do pass, and I will assign the floor statement to Senator Wynn, if you're not too sick of talking about it. Oh, okay.
Okay, we're at Senate Bill 294 now. This is a bill brought by Senator Doñate, which revises provisions relating to the safe storage of firearms. We heard it here on April 5th. This bill, Senate Bill 294, establishes the Safe Firearm Storage Act, which removes current provisions of law governing safe firearm storage and replaces them with new provisions, including but not limited to more specific language defining what constitutes such storage, and affirmative defense to the crime of unsafe storage if a child accesses a firearm in certain circumstances, requiring a firearm dealer to provide a locking device upon the sale or transfer of a firearm and post notice of the legal consequences of unlawful storage. It also adds active shooter preparedness drills as required, training to be provided by public and private schools to employees and students. And it requires the Department of Health and Human Services to develop and implement a safe firearm storage education campaign for public dissemination and make relevant information from that campaign available via the internet. There is an amendment provided by Senator Doñate at the hearing on the bill. It's attached for review. It removes Section 3 of the bill, which is the Safe Firearm Storage Act and the penalties associated with it, and retains the current language in statute. It also adds new language in Section 8 and 9, revising provisions concerning how governing bodies of charter schools and school districts, which have more than 50,000 pupils enrolled, are to train officers, educate students and staff, and communicate with parents and guardians regarding active assailant training, preparedness, and notification.
All right, are there any questions on the bill or the amendment? I don't see any questions. I would accept a motion to amend and do pass. All right, we have a motion from Senator Orenshaw, a second from Senator Wynn. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. I'll be a no on this. While I admire the intent trying to protect children, this is going to disproportionately affect people who are in unsafe neighborhoods, who have a need to have reasonably quick access to firearms. The number one reason people in those neighborhoods are actually buying firearms is for self-defense. And while it's nice in a nice safe place like where I live to say that you should store all your stuff in this manner, the reality is that for people, especially women, who live in dangerous neighborhoods, they need to have quick access to a firearm for their own self-defense. And what this will do ultimately is, if it's enforced, will actually be disproportionately used to penalize people in difficult areas that need quick access to firearms for their own self-defense. Cops can't be everywhere all the time. And what this is going to do is create a barrier for people to be able to quickly get a firearm and repel a potential person in the home that doesn't belong there. And just we're going the wrong direction on this. While I want to protect children, I think the number one reason you see people in those neighborhoods with firearms is for their own self-defense. So I'm a strong no on 294. Thank you, Madam Chair.
Of course, I just want to clarify, though, that the bill has been amended to remove the safe storage portions. It leaves in the educational portions and the training portions for school and law enforcement personnel.
If that's correct, I apologize. I just got the bill literally, 2 hours ago, so I didn't get a chance to read all of the amendments. So I'm still going to vote no, but maybe I'll change my vote on the floor if, in fact, all the storage portions have been removed. So that's true. That's a good move in the right direction. Thank you.
Thank you, and I completely understand. We have all been trying to keep up with the copious bills and amendments, so that is the intent of the amendments, and certainly appreciate that you're not in a position to change your vote right now, but we can continue the conversation.
Very good.
Senator Krasner.
Thank you, Chair. So I also just received the packet. So I'm going to vote no now, but reserve my right to change prior to floor after I get to read through the amendment. Thank you.
Any other discussion on the motion? All right, not seeing any. All in favor, aye. Aye. Any opposed, nay? Nay. All right, looks like nays are Senators Stone, Krasner, and Hansen. But the motion to amend and do pass carries, and I will assign the floor statement to Senator Doñate.
Okay. Moving on, we are now at Senate Bill 335, which relates to real property. This is a bill brought by Senator Orenshaw that we heard on April 4th. Senate Bill 335 repeals current provisions governing the summary eviction process and sets forth new provisions governing the process for both residential and commercial tenants in instances where they have defaulted on their rent. and when being evicted for other reasons. Among other provisions, the bill also requires a landlord to begin the eviction process by filing an affidavit with the court. It revises provisions governing when and how a sheriff or a constable is to accept and act on an eviction notice, and revises timelines for the process, including when a notice must be posted and how after that posting a tenant is to be removed from the premises. The bill sets forth guidelines for a tenant to contest an eviction and for a mediation process, and addresses applications for rental assistance, and provides that a court is to dismiss an eviction if rental assistance is granted during the eviction process. There is an amendment offered by Senator Orenthal in consultation with Jonathan Norman of Legal Aid, and I will go through the bullet points of that amendment very quickly. It removes sections 2 through 8 of the bill. It inserts language enabling a justice court to create an eviction diversion court and providing guidelines for participation. It removes references to eviction mediation in section 9 of the bill. It adds language clarifying what constitutes a pending application for rental assistance and setting a time limit for when such must be filed. It requires an agency in receipt of a rental assistance application to inform involved parties when the application is approved or denied. It gives the court power to adjudicate issues unrelated to rent and award up to $1,000 in the case of a landlord raising issues as a pretext. It clarifies when a rental assistance defense is in bad faith, and it provides that a tenant may be evicted if they cannot pay the amount owed in excess of any rental assistance they have received. And that's all, Chair.
All right, any questions on the bill, or do you want to make some remarks, Senator Orenthal?
Thank you, Chair Scheibel. I'll be brief. Certainly want to thank Jonathan Norman of Legal Aid Center, Judge Zaragoza down in Southern Nevada. I think that, I know they've worked tirelessly on trying to come up with something that is workable for the courts that I think will help protect our constituents, and I hope the committee will consider supporting it.
Thank you. Any other remarks? Senator Stone, was that a hand? Go ahead.
Yes, thank you, Madam Chair. I have not had a chance to review the amendments. I always applaud my colleague for protecting people, especially vulnerable constituents in Nevada. I join him in those protections. Prior to COVID, the eviction process was, I believe, fair and expeditious in cases where people weren't paying rent or you had problem tenants. Understanding the bill in its present form, and I haven't had a chance to review those amendments, although some of them are very attractive, I believe that this increased steps and costs and time in order for a landlord to get an eviction. And this is, again, is a landlord that has been here for 5 years and has never evicted anybody once. So I worry about the small mom and pops that this could delay them getting their units re-rented, causing them financial harm. And for those reasons, I'm going to vote no today, but as the chair said, she respects anybody changing their vote on the floor, which I greatly appreciate, and I look forward to studying those amendments. Thank you.
Thank you. Actually, I'm going to put a clarifying question on the record first, because this might be where a couple of these are going. It's my understanding that the amendment removes the bulk of the bill, the first 8 or 9 sections, and so this bill has 2 components left in it. One is authorizing the diversion courts for eviction proceedings, and 2 is refining the language around stays of evictions when someone has a pending rental application. I don't know if you want to answer Mr. Norman or
And that's
Senator
correct. But if
Orenthal.
Mr. Norman can jump into it, I think we have Judge Zaragoza trying to get through on the phone as well from Las Vegas.
Chair, members of the committee, thank you so much. I think that's right, Chair Scheibel. It's those 2 components, and we really listen to the committee. And Judge Zaragoza, I don't think she's trying to call in, but she's hearing music, she said. But we really tried to craft something that put limits on that defense so that landlords weren't waiting for long periods of time. So the language, bullet point 4 and on, is to kind of weed out the potential bad actors that I think this committee was worried about, to make sure that people who are most at risk are being able to access this defense.
Thank you. Senator Krasner, did you still have a question?
I just had a comment. I'm still going through the amendment also that I just received. So I'm hoping to get there, but I'm going to vote no now and reserve my right to change prior to floor. Thank you.
All right. Any other questions? Not seeing any, I would accept a motion that I don't think I've accepted yet to amend and do pass. All right. We have a motion from Senator Wynn, a second from Vice Chair Harris. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay? Nays are Senators Stone, Krasner, and Hansen. The rest are ayes, and with that, the motion to amend and do pass carries, and I will assign the floor statement to Senator Orenshaw.
Next up, we have Senate Bill 343, which relates to fentanyl and derivatives of fentanyl. This is sponsored by the Majority Leader. We heard it here, as I mentioned before, on April 10th as a companion bill with SB 35. So I won't go through this whole summary of the bill again because in its original form it was almost identical to SB 35. I will just speak to the amendment, if that's all right, Chair. The amendment, as proposed at the hearing by Senator Cannizzaro and Attorney General Ford, does three things to this bill. It strikes provisions establishing the mid-level and high-level fentanyl trafficking offenses, but retains the low-level offense. It amends the definition of fentanyl to mirror that in SB 35, and it adds Good Samaritan language concerning overdose reporting to the bill. That's it.
All right, any questions on this bill or the amendment? Seeing none, I would accept a motion to amend and do pass. We have a motion from Senator Krasner, a second from Senator Stone. Any discussion on the motion? Senator Harris.
Thank you, Madam Chairman. I reserve my right on this one as well.
All right. Senator Orenshaw.
Same here as Senator Harris. Thank you, Chair.
Understood. Thank you. All right. Not seeing any further discussion. All those in favor, aye. Aye. Any opposed, nay. It is a unanimous vote to amend and do pass Senate Bill 343, and I will assign the floor statement to the Majority Leader Cannizzaro.
Apologies, we're at 367 now. Senate Bill 367 relates to public safety. This is a bill sponsored again by Majority Leader Cannizzaro. We heard it on April 3rd. It provides that a person who possesses or uses a gun during the commission or in furtherance of a drug trafficking crime in violation of Chapter 453 of NRS is guilty of a Category B felony. This violation is in addition to any other violation committed as part of the drug trafficking offense. It provides that each dangerous weapon or metal-penetrating bullet owned, possessed, manufactured, sold, disposed of, handled, used, or carried by or otherwise under the custody or control of a felon who is a prohibited person from owning or possessing any firearm constitutes a separate violation of the law. And finally, the bill allows courts, juvenile justice agencies, and child welfare agencies to share confidential records of a minor with federal, state, or local governmental entities that must access those records in order to conduct a background check as is required by the federal bipartisan Safer Communities Act of 2022. Clark County has offered a friendly amendment that is attached for the committee's review. That amendment strikes Section 8 of the bill and replaces it with new language setting forth the conditions under which the records of a child who is at least 16 years of age and who has been ordered admitted to a mental health facility must be provided by the court to the central repository for use to perform background checks relating to the purchase or possession of a firearm. The central repository is to ensure that such information is included in the National Instant Criminal Background Check System and may take steps to include the information in appropriate databases of the National Crime Information Center. These provisions do not apply if the child has sought mental health treatment voluntarily, and the amendment also provides a means by which a person who is the subject of a report made under the provisions of this bill may petition the court to have the record removed upon certain findings being made. There's also an amendment that we got this morning, which I haven't reviewed yet, from the public defenders, which I believe is a friendly amendment. It seeks to bring the bill into line with federal law, with a couple of court cases, I think, or maybe one court case, and with sentencing guidelines, and I believe we have several people here who could speak to that amendment, Chair.
Thank you. I'd like to invite Senator Cannizzaro up to talk us through some of the amendments.
Thank you, Madam Chair and members of the committee. Nicole Cannizzaro, Senate District 6. So the committee should have in front of them the two amendments, one from Clark County. We had briefly discussed that at the hearing with the committee to make some revisions to how the background check process will work. We were amenable to those changes, and so you have that amendment as it pertains to that piece of the bill. With respect to the amendment that we have accepted from the public defenders, both Mr. Pirro and Ms. Roth, they asked to remove Section 2, so that would be removed from the bill, and then to amend Section 3 so that it is just for their, it's very specific in that if you are a prohibited person, you are prohibited from possessing a firearm, and that each firearm that you may possess is a separate violation. And then you'll see in subsection 2 on page 2 of that amendment that it has, as used in this section, dangerous weapon means. We are going to strike that piece and just put for the definition of firearm as it currently exists in NRS, just so that there's no confusion and we're not creating multiple definitions across statute that identify what a firearm is. There's already a definition in NRS for firearm, and so we're just going to refer to firearm so that that is clear, and that the intent of this bill is clear, that each firearm would constitute a separate charge. And so that's the amendment to Section 3. And then any other conforming changes that may need to be made between the two amendments, the one from Clark County and the one from the Public Defender's Office. But I do believe that that amendment should address some of the concerns that we had heard. And when I was in front of this committee presenting the bill, we indicated we'd be willing to talk about some of those changes. And I believe that this amendment does solve some of those concerns that were raised at the hearing.
Thank you so much. There's a question from Senator Hansen.
Thanks, Madam Chair. Well, one of my big issues with it was what I call stacking charges, separate violations of law. So it sounds like you cleared up some of it, but in the original bill, it talked about dangerous weapons, and each bullet could theoretically be a separate felony charge, and then you got a machete in there and different things like that. What's left in the bill now with after the amendment that would still allow the prosecutor, basically, or the charging officer to write up a series of stacked felony charges?
Thank you for the question, Senator Hansen. Through you, Madam Chair, to Senator Hansen.
Oh, please go direct.
Thank you. Nicole Canizaro, Senate District 6. So first, the piece that has been referred to as stacking, which I would contend is not actually stacking, because what we're not talking about is sort of multiple charges arising out of one course of conduct. Be akin to if you have 5 stolen vehicles in your possession, you will be charged with 5 counts of possession of a stolen vehicle. And so this would make clear that if you are already a prohibited person, and that's at NRS 202.360, so you are already prohibited, for every firearm that you may have in your possession. If it is 1, that would be, you could be charged with 1 count of possession of a firearm by a prohibited person. If you had 5, that would be 5 counts. If you had 50, that would be 50 counts that you could be charged with if you're a prohibited person and have those firearms in your possession. What this amendment will also clarify is that it is just pertaining to firearms. It's not the metal projectiles, it is not machetes, it's not other dangerous weapons. And so what we want to make sure is that we just have the definition of a firearm as we would commonly know and what is currently defined in NRS. So it would still allow for multiple charges for those firearms to be charged, but it would not include anything else other than what we currently have as a definition as a firearm.
Very good. Actually, that alleviates a lot of my concern. I mean, I was a no, but now with all the amendments, I'm still going to be a no. But I just want to have a chance to read. I just want to read the amendments and stuff. So I may switch and vote yes on the floor, but just a matter of I haven't had a chance to read it. But it sounds like you've answered my concerns. But anyway, I appreciate that. Thank you, Madam Chair.
Of course. I think there's also a question from Senator Wynn.
More of a comment. I just wanted to thank the majority leader for taking into consideration some of the amendments that I had concerns with, particularly with other, other weapons and the metal piercing bullets, just because I saw that as being very dangerous. But I appreciate you taking that into consideration in the amendments that are proposed. So thank you.
And I also just wanted to clarify that always a prosecutor has discretion to choose how they charge a particular crime. So if there were some reason that it didn't make sense to section them out, they could still file a criminal complaint charging 1 count of possession of a firearm and then name 3 firearms in that count.
Senate District 6 is where I represent. So yes, that is correct. Nothing about this or frankly any piece of legislation, right, removes the discretion that might come from judges in the courts, that might come from a charging document and how that's decided whether charges are they're going to be pursued or not based on evidence, or even ultimately what might come of plea negotiations. Those are all pieces that, as much as we pass legislation, still exist from a discretionary standpoint and allow us, I think, my opinion would be the flexibility to address individual circumstances, because trying to put everything in one black and white box can be very difficult.
Thank you. Were there any other questions? All right, not seeing any, I would accept a motion to amend and do pass, clarifying that this would be with the amendment proposed by Clark County, the amendment proposed by the public defender, and an additional conceptual amendment to replace dangerous weapon with the existing definition of firearm in the Nevada revised statutes. All right, we have a motion from Senator Orenshaw, a second from Senator Nguyen. Any discussion on the motion? All right then, all in favor say aye. Aye. Any opposed, nay? All right, looks like the nays are Stone, Krasner, and Hansen. The rest are ayes. And with that, the motion carries, and I will assign the floor statement to Senator Cannizzaro.
Okay, we're now on Senate Bill 379, which is a gaming bill. It's brought by Senator Dondero Loop and Senator Cannizzaro. We just heard it here a couple of days ago. Senate Bill 379 requires the Gaming Commission to adopt regulations governing secondary sports pool brokers, including requiring that they be registered with the Gaming Control Board, that their employees be registered in the same manner as our other gaming employees. The Commission is also to establish a fee structure for such registrations, and the bill provides that it is illegal to operate as a secondary sports pool broker without proper registration. Regulations must be adopted specifying duties relating to the manufacture and repair of any equipment or interactive gaming systems used by such an entity, and the bill requires quarterly and annual reporting on subjects related to a quote-unquote foreign gaming manufacturer, which is defined as a business that receives revenue from gaming devices located outside the state of Nevada. There are three amendments, Chair, that were two which were proposed during the initial hearing on the bill by two students from the Boyd School of Law, and the third offered by the chair herself. And so I will go through the three of them individually. They do not conflict with each other as far as I know, and they should all be able to be accepted together or individually as the committee sees fit. The first is offered by Senator Scheibel, replacing Section 3 of the bill with new language requiring the adoption of regulations to register and maintain strict regulations of sports wagering ticket brokers. This amendment also replaces Section 6 of the bill with language providing that certain provisions of Chapter 465 of NRS do not apply to the operations of a properly registered sports wagering ticket broker. The second amendment was offered in testimony by Douglas Billings and is intended to remove the distinction between operators and manufacturers included in the original bill, to reduce foreign gaming reporting obligations, and to further align the statute with the Control Board's expected practices with respect to foreign gaming reports. The third amendment was also offered in testimony from Veronica Denisova, and it would require the Gaming Commission to adopt provisions defining the responsibilities associated with the manufacture or repair of gaming devices and other related equipment that must be met in order to be considered a gaming employee under NRS 463.0157.1 sub 1.
Thank you so much. And I would just like to comment that I did hear the committee's concerns as well as stakeholders' concerns about the licensing versus registration portion of the secondary sports wagering companies. And so the law students came to me, some industry stakeholders came to me, asked for help to kind of figure out that piece of it. I know that we are still working on it. And so I appreciate everybody coming to the table to talk about some possible solutions. I think that it's my understanding that the language proposed in my amendment, which is contained in the work session document, is an improvement. Might not get us all the way there, but we're on the path to solving that problem, which is only one piece of the larger package of SB 379 that includes those other provisions that I think everybody was in agreement on. So do you want to make a comment? Go ahead. Okay. Are there any questions on the bill or the amendment? All right, not seeing any, I would accept a motion to amend and do pass. All right, we have a motion from Senator Wynn, a second from Senator Harris. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. We have a unanimous vote to amend and do pass, and I will assign the floor statement to Senator Dondero Loop.
Okay, we are now at Senate Bill 389. This was sponsored by Senator Scheibel and presented here on April 13th with Minority Leader Sievers-Gansert. And it relates, well, it provides, Senate Bill 389 provides that the same penalties that apply to a person who commits the crime of facilitating sex trafficking against a child also apply if the person commits the crime against a police officer posing as a child or a person assisting a police investigation by posing as a child. The bill authorizes a sex trafficking victim to apply for compensation from the Fund for Compensation of Victims of Crime for up to 60 months after the event for which the compensation is being claimed. And it requires various entities within the state that work on human trafficking and sex trafficking to collaboratively prepare a comprehensive report concerning human trafficking in this state for submittal to the Joint Interim Standing Committee on the Judiciary on or before July 1 of each even-numbered year. There is an amendment offered by the chair that is attached for the committees to review. The amendment adds language excluding the sharing of any information in the report required in Section 4.2 of the bill that would compromise a victim's safety or privacy. It also allows entities that receive money from the contingency account for victims of human trafficking to use that money to establish a pilot program or programs for alternatives to law enforcement response to victims of human trafficking, and it makes a $1 million appropriation to the contingency account from the State General Fund. That's all.
All right, any questions on the bill or the amendment? All right, we have a motion to amend and do pass. We have, sorry, that motion was from Senator Stone. The second was from Senator Wynn. Any discussion on the motion? All right, all in favor, aye. Aye. Any opposed, nay. We have a unanimous motion to amend and do pass, and I will take the floor statement.
Next up is Senate Bill 410, which is a juvenile justice bill sponsored by Senator Orenshaw. We heard it here just on April 13th. The bill extends the amount of time from 180 days after arrest to 270 days after arraignment that an employee of a juvenile justice service entity is allowed to resolve pending criminal charges before a Department of Juvenile Justice Services must terminate the employee unless the employee is granted additional time to resolve those charges. The bill also clarifies the meaning of a quote-unquote substantiated report of child abuse or neglect in relation to provisions governing how a child welfare agency is required to address an applicant or employee who is the subject of such a report. Clark County has submitted a friendly amendment that was mentioned in testimony on the bill. It clarifies that if an employee has appealed the substantiation of a report of child abuse or neglect, but the hearing has not yet occurred through no fault of the employee, the Department of Juvenile Justice Services must extend the amount of time for the hearing to occur and a decision to be rendered. It also provides that an employee arrested for a criminal offense enumerated in NRS 662G .223 must resolve the matter within 180 days, except that the department may allow the employee additional time to resolve the pending misdemeanor charges for good cause shown, and must allow the employee additional time to resolve pending misdemeanor charges against the employee if through no fault of their own the charges have not yet been filed. And lastly, the amendment redefines slightly the term substantiated report of child abuse or neglect.
All right, any questions on the bill or amendments? Senator Stone.
Thank you, Chair. First of all, I want to applaud the author. These are employees that have contact with kids, and there are instances where people are wrongly accused, and they deserve the due process that the author is trying to grant them, and we know that our legal judicial system doesn't always work as fast as we would like. I would just like to just ask for the record that that the accused, until they have their trials adjudicated, will not be having contact with children within the department until that has been decided. Is that correct?
Chair. James Orenshaw, Senate 21, through you to Senator Stone. I believe there was testimony at the hearing that among the different accusations, some could be DUI, but some, if there was an allegation of child abuse or neglect. I recall testimony at the hearing that often, till those allegations were resolved, folks were working in areas where children were not. I believe Mr. McCann is here. If with the chair's indulgence, Mr. McCann. If you
Absolutely.
can provide any further enlightenment on that, but that's what I believe was the testimony at the hearing. I don't want to speak for
Thank you.
Department of Juvenile Justice Services, but I believe he's got more information. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee and staff. Rick McCann, Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. Thank you for the question, Senator Stone. No, if somebody is going to be charged and they have their opportunity down the road, we don't want them with kids.
Thank you.
And that is in the statute currently. Thank you.
I'm happy to support the bill under those circumstances. Thank you.
All right. Any other questions? Seeing none, I would accept a motion to amend and do pass. Yes, amend and do pass. All right. We have a motion from Senator Wynn and a second from Senator Stone. Any discussion on the motion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. All right. We have a unanimous motion to amend and do pass, SB 410, and I will assign the floor statement to Senator Orenshaw.
Okay, the final bill on this work session is Senate Bill 415, which relates to juvenile probation. Just heard it here yesterday. This is a committee bill brought on behalf or on a recommendation from the interim Judiciary Committee. Senate Bill 415 sets forth provisions under which a juvenile court may place a child on probation and with certain exceptions limits juvenile probation to 6 months. The juvenile court may extend probation if a preponderance of evidence presented at a hearing results in a finding that such an extension is in the child's best interest. Probation may be extended in 6-month increments up to a total of 18 months. Notice of hearings regarding the extension of probation must be given to the child, the probation officer, and the child's parent or guardian, and the court must allow the parties to present evidence and testimony and must consider whether the probation officer believes that the child's probation should be extended. Clark County has offered an amendment at the initial hearing on the bill, which is attached for the committee's review. It sets forth provisions clarifying when a child may be placed on probation. It requires use of the youth level of service assessment to guide terms of juvenile probation. It limits probation to 18 months, except in cases of murder or attempted murder, or where otherwise expressly authorized by statute. It authorizes probation extensions of more than 6 months if permitted by state or federal law. It allows probation to extend beyond 36 months upon agreement of the interested parties, and it allows the juvenile court to retain jurisdiction to oversee the payment of restitution.
All right. Any questions on SB 415 or the amendment? I don't see any questions, so I would accept a motion to amend and do pass. We have a motion from Senator Wynn and a second from Vice Chair Harris. Any discussion on the motion? Not seeing any. All those in favor, aye. Aye. Any opposed, nay. All right, we have a unanimous motion to amend and do pass, SB 415. I will take the floor statement. And that brings us to the end of our work session. Good job, everybody. We will now move into bill hearings for today. And unless anybody jumps up out of their seat and tells me to take them out of order, I will take them in order. Starting with SB 407, I'll go ahead and open up the hearing. Please go ahead.
Good afternoon, members, Chair, and members of the Senate Judiciary Committee. For the record, James Orenshaw, I represent State Senate District 21. I'm very fortunate to have with me Julia Gold and Michelle Rafferty here in Carson City, and down in Las Vegas, Alan Freer. And appreciate your hearing Senate Bill 407. You may ask, why is Senator Orenshaw presenting Senate Bill 407? Back in law school, I struggled to get a C in my trust and estate class and just barely got through that. So I'm certainly not the authority in trust and estates, but I'm lucky to have some of our state's top authorities here to present Senate Bill 407. Senate Bill 407 is the culmination of 18 months of work of the probate trust and estate section of the State Bar. It was presented to the State Bar Board of Governors and I believe received a unanimous vote in support last August. With that, Chair, with your permission, I'd like to turn it over to Ms. Gold, Ms. Rafferty, and then to Mr. Freer in Las Vegas, then I'm happy to not answer any questions and divert them to these very able attorneys. Thank you.
Thank you, Chair and members of the Senate Judiciary Committee. My name is Julia Gold, and thank you so much for the introduction. Just so you know, the one thing that happens when the bill does go to the Board of Governors is it is vetted by every committee section. So family law, every committee section has vetted this bill and had no objections, and it was approved 100% by the Board of Governors. And so after he gave a nice introduction, we were going to go through a summary. I know that your time is very tight, and so we'll do this pretty quickly. And if you have questions, please interrupt. Between the three of us, we will be able to answer your questions. So I'm just going to dive in. Section 1 of the bill amends the statute on jurisdiction and venue on estates to clarify between the separate requirements for jurisdiction and venue and offer greater flexibility to adjudicate estates. And just one other thing I didn't say is that this bill primarily amends Title 12 and 13, which deals with trusts and estate law. Section 2 and 3 amends the support of family and small estate statutes to clarify the relevant needs and resources to be considered in establishing a probate homestead and to provide a mechanism for court appointment of a specific person other than a duly appointed personal representative to execute set-aside documents. So it's to hopefully make it easier to proceed with estates that are under $100,000. Sections 4 and 5 amend the sales and conveyances statutes, so it will increase the efficiency when we are doing a sale not under the Independent Administration of Estates Act, and it eliminates unnecessary correspondence with people that do not have an interest of the property being sold. Section 6 amends the notice provisions of NRS 155.010, and it permits electronic service where available. And so if someone does agree to receive service via email, we can do that. Those are the sections that I was going to cover. Mr. Freer, who is here via audio-visual, will cover the remaining sections of the bill. If anybody has questions on the sections that I covered, I'm happy to entertain those questions.
Let's go ahead and kick it to Mr. Freer.
Good afternoon, Madam Chair. Alan Freer for the record. Again, I'd like to thank Senator Orenshaw for sponsoring this. Briefly, Section 7 provides further clarity with respect to amending declaratory relief statutes to include the concept of allowing an interested person to bring a declaratory relief statute. That the interested person is a defined term under NRS 132-185. So this brings in who may bring it in line with persons who have standing in probate and trust proceedings. Sections 9 and 16 are new sections added to NRS Chapter 163 and 164 on how to define, establish, and reinstate the incapacity and capacity of a trustee to serve as trustee and provide some guidance to the courts on what standards to be used. Sections 10, 13, and 18 have been drafted to streamline the court process and further protect beneficiaries' private information from becoming public records. So what these sections do is they provide a statutory right in favor of those beneficiaries to keep confidential certain information relating to trusts that otherwise would first be subject to public record and then only be made private upon going through a motion process to get those records deemed confidential. These sections were actually done as part of a canvassing of the United States, and we struck a kind of a middle ground between states that just automatically make any case filed for a trust proceeding confidential versus those states that have no protection. So we figured, we as a committee felt that it was best to have kind of a middle ground where certain information would be protected. All of it is still subject to the district court that will have discretion and the final say regarding the privacy of the information. Section 11 provides clarification to provide a better definition of a support interest. It was ambiguous before that, and so it provides that a support interest is a mandatory requirement to support a beneficiary. Section 12 is designed to keep up with the evolving area of trust law and the new concepts within the last few sessions that we've passed with respect to trust protectors. This sets a default standard that a trust protector is a fiduciary and subject to fiduciary duties to better protect beneficiaries. However, that fiduciary capacity can be changed by the settlor in the trust document itself. Section 14 is the most expansive clarification in the bill. It amends NRS 164.010 in light of a constitutional long-arm jurisdiction concern raised by the Nevada Court of Appeals. And so this goes in and clarifies when and how a court can assume jurisdiction and the factors relevant for determining venue. Section 15 clarifies what information a trustee is required to provide a beneficiary in notice of irrevocability under NRS 164.021. Again, this is a clarification in light of some recent Nevada Supreme Court opinions and provides what information a trustee may provide to the beneficiaries. Lastly, Section 17 is merely a technical correction for the Uniform Principal and Income Act. In the original drafting and passage of the UPIA, it was inadvertently admitted under 164.796 that a trustee is exonerated from taking action under the Uniform Principal and Income Act. Presently, it just reads he's exonerated if he fails to take action under the Uniform Act. So with that, we have, that's the language of the bill. I do have one question to pose to the floor, is we do have a friendly amendment that we are offering. I don't know if the Madam Chair would like me to discuss that now or if that's going to be taken up at a later date.
No, go ahead and walk us through the amendment, please.
So the amendment, just a couple of minor amendments. Section 1 is amended. The original drafting of the BDR had interested party, and we changed that to interested person to bring that in line with 132.185. Section 10 was intended to provide a definition of what confidential information would be protected. And in the drafting process, it became an absolute trigger on the following information is confidential, which was not the intent. So we've amended to propose to strike Section 10 and include the definitional section that was in 10 as a definition under Section 13. And then lastly, Section 14 is just a cleanup to NRS 164 to correct transcription errors in the BDR drafting process and conform it with that was with the language that was presented to the State Bar. And with that, if there are any questions, I'd be more than happy to entertain those, or otherwise I'll turn the time back over to Senator Orenshaw.
And Chair Scheibel, members of the committee, if there are any questions, I'm happy to try my best, and I've got some very able co-presenters with me who can bail me out.
All right, any questions from members of the committee? All right, I don't see any questions, so we will move to testimony in support of SB 407. Right, that's what we're doing. Anybody wishing to give testimony in person is invited to the table in Las Vegas or Carson City. But not seeing anybody, we will go straight to the phones for support testimony on SB 407.
Thank you, Chair. If you would like to testify in support of SB 407, please press *9 to take your place in the queue. We have no callers in support at this time.
All right. Anybody in opposition to SB 407? Now's the time to come up to the front in either Las Vegas or Carson City. But not seeing anybody, we'll go to the phones for testimony in opposition to SB 407.
If you would like to testify in opposition of SB 407, Please press star 9 to take your place in the queue. We have no callers to testify in opposition at this time.
And finally, we're going to neutral on SB 407. Anybody wishing to give neutral testimony is invited to the front of the room in Carson City or Las Vegas. But not seeing anybody, we will go to the phones for testimony in neutral.
If you would like to testify in neutral for SB 407, please press star 9 to take your place in the queue. We have no callers to testify in neutral.
All right, then that brings us to the conclusion of the bill. If you have any closing remarks, now would be the time.
Chair Scheibel, committee, thank you for hearing the bill. Professor Michael Higdon over at UNLV Boyd Law School would be very proud to see me co-presenting with Ms. Gold, Ms. Rafferty, and Mr. Freer, notwithstanding how much I struggled in trust and estates. Appreciate their help, and I hope the committee will consider moving this bill forward. Thank you.
All right, thank you. I will now close the hearing on SB 407, and I would accept a motion to amend and do pass.
So moved.
All right, there is a motion from Senator Stone, a second from Vice Chair Harris. Any discussion on the motion? All right, all in favor, aye.
Aye.
Aye. Any opposed, nay? All right, we have a unanimous, Senator Hansen is absent, excused, but we have a unanimous vote from the members present, and with that, the motion carries, and I will assign the floor statement to Senator Orenshaw. Of course, and I will hand the gavel over to Vice Chair Harris.
Thank you, Chair. We're going to open up the hearing on Senate Bill 416, but we will not be taking any questions, so I don't have to call on you.
Good afternoon, Senate Judiciary Committee. My name is Melanie Scheibel. I am the State Senator for District 9, and I am very happy to be here today presenting SB 416 to you. SB 416 is the product of many months, years actually, of work by a lot of people who are extremely invested in ensuring that our criminal justice system works. And SB 416 can also be referred to as the cost of incarceration bill. It was this bill comes out of the Joint Interim Standing Committee on Judiciary because last session, when I chaired that committee, we heard from numerous family members, formerly incarcerated people, staff at the Department of Corrections, staff in the judicial system, attorneys, and other impacted folks about the experiences of people who are incarcerated in the Nevada Department of Corrections. And one of the consistent themes was that being incarcerated is expensive. We learned a lot starting well before the Interim Judiciary Committee, but especially through the 2021 legislative session and into that Interim Judiciary hearing or session, we learned a lot about the functions of the Department of Corrections, some of the ways that they find revenue sources, some of the fees and fines that are assessed to people who are incarcerated. And our committee took very seriously our obligation to take a close look at those and ensure that they were fair and ensure that they made sense from a policy standpoint for our community and for our state. That's about all the credit I can take for this bill, is having listened a lot and really wanting to see this come to fruition. But the lion's share of the work has been done by our advocates, two of whom are with me today, Nick Shepak and Katie Brandon. I knew it was a name that ended in N. Katie Brandon and Nick Shepak from the Fines and Fees Justice Center are going to present the bill to you, and we would all be happy to answer any questions you might have.
Thank you, Senator Scheibel. Thank you, Vice Chair and committee members. My name is Nick Shepak, and I am the State Deputy Director of the Fines and Fees Justice Center. As was mentioned in the opening remarks, this bill is a culmination of more than 2 years of attention being drawn to the financial practices at NDOC. While the financial burdens from for-profit companies that contract with DOCs across the country were very apparent to all advocates, it wasn't until we started seeing 80% of individuals' deposits being deducted under the last administration that we realized that the financial system that we have built here in Nevada around the Nevada Department of Corrections is very burdensome and at times possibly predatory for individuals who are incarcerated and their families. So we took a deep dive with our partners at Return Strong through public records requests, conversations with the department to try to figure out what this system really looked like and what the impact was on Nevada's families. What we found was shocking, surprising. Nevada has some of the highest commissary markups in the nation. We have the second highest medical copay, which is over double the national average for people seeking medical care. The only state that has a higher medical copay is Texas. They, however, have a cap and exempt many, many things from the medical copay that we do not. We charge room and board to only individuals who are working. So if you have a job, you are punished financially. And we levy debt on individuals who are leaving prison. One individual left with $100,000 in debt, medical debt, when they were released from prison. That is, they are sent to collections if they are unable to pay that in a very short amount of time. Any savings that they may have in their savings account will be deducted down to $25. So many people leave with just $25 on an extremely predatory debit card. And what we see is huge profits made from things like commissary, to the point where we have an average of about $14 million in surplus that isn't spent, that rolls over year to year from commissary profits. I have with me, as mentioned, Fines and Fees Justice Center intern, Katie Brandon. She is a master's student at public health at UNR. She spearheaded a project to collect data from currently incarcerated individuals through a survey, and you have that entire report. We are only going to run through just a few of the more important findings in that report here. But I will walk you through the bill here first. So, Section 2 requires the department to establish an indigency standard for the retrieval of the remains of someone who passes away at NDOC. As you will hear later, it can be extremely financially burdensome to retrieve the remains of a loved one who dies within NDOC. Section 3 ends the cap on the amount of money that an individual is allowed to spend at the commissary and caps markups at 5%. Section 4 ensures that offenders' savings, which is millions of dollars over the 10,000 people, are held in an in-state bank instead of the out-of-state for-profit bank that they are currently held in. Section 5 ensures that incarcerated persons do not incur medical debt from accidents, self-harm, or sickness while incarcerated. However, they can still be charged for medical debt if they cause harm to another individual. Section 5 also removes salaries for state employees from the offender's store fund. We're one of the only states in the country that has staff, full-time staff, employees of the state that are funded solely through deposits of money put in by families that are then spent at the store. This is a backdoor tax directly on the families of the incarcerated to fund staff at NDOC. Section 6 ensures that medical debt is not incurred for accidents or self-harm. Yes, again, so that would be what we call man-down fees. And that money is not, gate money is not deducted from individuals who are serving life without parole or who are on death row. Right now, money is taken and put into a savings account for when they leave, even though they have no feasible chance of leaving the Nevada Department of Corrections. It also ensures that they are not incurring medical debt for prescriptions or prosthetic devices. Section 2 ends medical copays and man-down fees. Man-down fees are emergency medical fees if you hurt yourself, either because you have become suicidal and you have attempted to take your own life, or if you have a recreation injury such as playing basketball and you hurt your ankle. If you need emergency medical attention, you are charged an additional fee on top of the medical fees just for receiving that attention. Section 7 puts the same caps on the package program, which is ordering through a catalog as we have placed on the commissary. Section 8 ends room and board charges. Section 9 ensures that everyone leaves with $100 instead of the $25. Now, most individuals should have at least $100 in their savings prior to leaving, but if they do not, that would require the NDOC to ensure that they have at least $100 upon release. Section 9 discharges outstanding medical and departmental debt upon release, so people are not left with $10,000, $20,000, $30,000 in debt to start back in society. It does not touch restitution at all. They remain beholden to pay restitution, and we believe that eliminating this debt will make that easier on them. Section 9 gives the option for a check or a card upon release that has the money, and it eliminates the predatory fees that now exist. And Section 9 clarifies that restitution is still owed by victims because that is important to everyone. I will now walk through a little bit of what each one of these items looks like briefly, and I will turn over each section to Ms. Brandon to show you some of the data. Starting with medical. As mentioned, we have the highest copays, second highest copay in the country. This is a burden to access to medicine. What we've found is individuals, because of this copay, do not access medical until they are very sick, costing the state a bunch more money and causing them to have worse health outcomes. There are many states that do not charge these copays: Illinois, Missouri, Montana, Nebraska, New Mexico, New York, Oregon, Vermont, Virginia, and Wyoming all do not have medical copays. As mentioned, we have man-down fees for people who commit self-harm or hurt themselves in recreation. We have spoken with many individuals who've been charged these many times. This is also something that is fairly unique to Nevada, and it discourages people from seeking the care that they need. These man-down fees can range anywhere from $25 to $50 to well over $100. And I will now turn it over to Ms. Brandon to talk about the survey.
Good afternoon, Vice Chair and committee members. My name is Katie Brandon. As Nick mentioned, I am the public health intern at the Fines and Fees Justice Center and a Master of Public Health student at UNR. So we completed a survey over the last several months with several people who are currently incarcerated in NDOC facilities. So I'm going to be walking you through a PowerPoint, which you have access to the entire thing with a lot more data than we're going to share today in the interest of time. But these are just a few of the highlights. So we mailed surveys to members of Return Strong, which is our partner organization that works with currently incarcerated folks in Nevada, in November. They completed those surveys and mailed them back to us, and then we got surveys from 376 people between November and January of this year. To start out, I'll tell you a little bit about the man-down fees that would be eliminated in this bill. So we heard from 142 people, or close to 40% of our respondents, that they had ever paid a man-down fee for any emergency care while they've been incarcerated. 6.2% of the people that responded said that they had paid for self-harm, so suicide attempt or non-suicidal self-injury. Close to 12% had paid a man-down fee for a recreational injury. And then we were also curious about people who had paid for man-down fees for emergency care because of delayed medical care or prescription refills. So 21.5% had paid for emergency care that they needed because they didn't get medical care when they needed it originally, and 10% paid for emergency care because they didn't get prescription refills when they needed them. We also asked respondents about money that they owe for medical care that they've received. So about 97% of the respondents had actually ever had money taken out of their account for any medical care during the time that they were incarcerated. So almost everybody. We saw that 12% of the people that had paid money for any medical care had had upwards of $2,000 taken out of their account. So 30% of people currently owe medical care at the time that we surveyed them, and among those people, the average debt was $4,500. So at the average pay rate that people earn after deductions of $72 per month, this would take over 5 years to pay off. So we know that this is not actually how it goes. This burden really shifts to families. We also wanted to know about people who avoid medical care because of the cost, because we know that delayed medical care and diagnosis can lead to worse health outcomes and more emergencies, which, as Mr. Shepak mentioned, are much more costly to the state for both the people who remain in custody and who come out and are on Medicaid in communities. So we saw that 82% of respondents avoid medical care because of the cost, which is 2 times higher than the general United States population, which is about 41% of people who do that. And then I'll pass it over to Nick again to talk a little bit about commissary costs.
Thank you. Nick Shepak, for the record, State Deputy Director of the Fines and Fees Justice Center. When talking to families, we talked a lot about commissary and how expensive it was and what it was costing them, especially with inflation these days. Now, I do want to recognize and give a big shout out to Director Zuenda. Because we've been having these discussions, recently they have eliminated the markups on commissary for all hygiene items, which is a huge start. And we believe that this bill has the ability to codify some of the policies that are being implemented now. What we found through our research is that there is a 66% markup. Now, this number is slightly disputed because I think the math is done a little differently. When we look at a markup, we look at it the same way that a store does. You run it through a very simple formula that finds out what percentage of the original price is added to the item, giving you the markup. What we have found is that it is almost 66% across the board. That is after the high markups given by the for-profit companies that provide these items. The package program, there's a 20% kickback that goes to NDOC when somebody orders through the package program. NDOC has been subjected to regulations of their commissary practices since 2010. Which include developing regulations through the 233B process. However, there has been no formal regulations created in that time frame until now. This was found in an audit done by the governor's office last year. NDOC profits an average of $439,000 a month, or $14.2 million in gross sales annually from their commissaries. Most of this money comes directly from Nevada families. The Offender Store Fund has, as mentioned, a $14 million in profit that are not spent and roll over year to year. Around $4.5 million of profit in the Offender Store Fund are allocated to paying for salaries for state employees, and $2 million from the inmate welfare account are also allocated to paying for salaries. In talks with NDOC, we have heard that they have 28 positions that are fully funded through these funds. However, on this year's budget proposals, which you have in the exhibits, they asked for an allocation for 99 full-time positions. And really what this comes down to for us is the question of who pays for our criminal justice system. This is a system that, because we rely on incarceration as our corrections, is an essential government service. It is one that is intended to keep all of us safe. It is one that is intended to protect all of our communities. And yet a small portion of Nevadans, the families who have done nothing wrong except loved someone who is incarcerated, are paying for these positions and being charged this exorbitant amount of money. And through our research, Katie will show you how important commissary is and what the impact is on individuals.
Katie Brandon for the record. So in addition to asking those closed-ended questions, we also asked open-ended questions about anything else that people wanted us to know. And overwhelmingly, we heard about the portion sizes for the prison-issued meals. So I'll just highlight a couple of these quotes. which are currently portions are too small to sustain an average-sized man with necessary calories. Most of us must purchase food from canteen in order to make up for the small portions. Someone else said little food, maybe 1,000 to 1,100 calories per day. And someone else said, dinner is never enough to stop the hunger, so as you see, we have no choice but to pay for food. So I'm giving you this background information just so you can understand a little bit more why people need to buy food from the commissary at these high markups. So we asked respondents whether they buy food at commissary because the prison-issued meals are not enough, and 96.5% of participants said that this was true. We also asked whether people couldn't afford to buy a variety of items when they needed them, and 80.9% said that they couldn't always afford to buy food at commissary when they needed it. And as Nick mentioned, currently it is internal policy at NDOC to not have these markups on hygiene products, which is really exciting, and we'd like to see that codified because we saw that several people were not able to access necessary items when they needed them. So 74.4% of participants said that they couldn't afford to buy hygiene products, so toothpaste, shampoo, soap, deodorant when they needed them. Among female participants, 79.2% said that they couldn't afford to buy feminine hygiene products when they needed them. And 58% said that they couldn't buy over-the-counter medical items like antifungal cream, antacids, and pain relief when they needed them. And specifically with things like antifungal cream, this is really important to promote public health within the prison system, to make sure that prisoners are able to take care of things so that they don't spread them to other people. And I'll pass it back to Nick.
Thank you, Nick Shepak, Fines and Fees Justice Center. And to close us out on the areas that this bill touches on, it is what does it look like when you are released? So currently you receive a prepaid debit card from a bank in Logan, Utah, and the fees on that card include a $1.50 weekly maintenance fee, a $1.50 ATM account inquiry fee, a $2 inactive fee, a $2.75 domestic ATM fee, a $25 account closure fee, a $2.75 ATM decline fee, and a $10 fee to replace that lost or stolen card. These are some of the most predatory fees we've ever seen on a debit card, and when people are leaving with as little as $25, it greatly reduces the amount of money that they have when they're trying to re-enter society. And then there's the debt upon release. So in the audit from the Governor's Audit Division, they found that there is $10.4 million in outstanding debt, which includes $1.7 million in collections and interest fees. And the annual collection rate on this debt ranges between 0.53% and 1.60% over the last 3 years. This debt is uncollectible. However, it is setting individuals who were formerly incarcerated up with no chance at establishing a credit score and being hounded by collection agencies. Now, before we move to questions, I'll say this. This is a bill that deals with a lot, and this is a policy committee. This is major fiscal questions that come along with this bill, and we have received a fiscal note recently. That is our job to figure out with members and with our team which parts of this we can make happen responsibly for the state, responsibly for NDOC, and figure out how we can move this state to where we are funding our criminal justice system not on the backs of individuals who have a loved one who is incarcerated, but in a more economical manner. So I will say this openly now, this is likely not the final iteration of this bill, and we are dedicated to ensuring that we bring something responsible to Senate Finance that is workable for the state. And with that, we will be happy to answer any questions.
Senator Nguyen.
Oh, that's so sad. It hurts me. Thank you, and thank you for bringing this bill. I sit along with Vice Chair Harris on the Finance Committee that also addresses NDOC's budget. And so I guess what brings me probably the most concern, and if you could talk about this, these medical costs any of the medical costs, are they being incurred by the state as a part of their budgetary process when someone has to seek medical care in the prison?
Nick Sheepback for the record. It is my understanding that we budget for medical care within the prisons. When somebody is removed from the prison and does not spend a certain amount of time in a hospital, there's a cost that is levied against the prison system. They then pay that out of the inmate welfare fund, and the director can correct me if I'm wrong on this. And then the incarcerated individual is then charged that debt, and they are paying back what the system paid outside. However, it is my understanding that we have medical staff on site and paid whether or not an individual is receiving care, and even when they go and receive that care, the individual is being charged for those visits.
And I appreciate the part about the statistic that you put up earlier about the delayed medical care. I can only imagine that is costing us so much more. If you can treat, for example, an ingrown toenail before it turns into sepsis, I'm sure that cost of the ingrown toenail doesn't rise to the level, or people missing out on their medication and all of a sudden going into diabetic shock. That has got to increase care. So if there's anything that we can do, and as a part of this bill, which I think it would accomplish some of those things, to get people the treatment they need before it costs the state more money and it costs these families more money to treat something that went untreated. I think your statistics showed about 21% of the people with untreated care. Okay, and then I guess my other question is it's in the first, section 2 of the bill. Can you talk a little bit about how you came up with that 5% number?
Thank you, Nick Sheepback for the record. We came up with this 5% through looking at what is the average markup that we see at grocery stores and retail stores. And we actually also used what they do at our largest detention center. So at Clark County Detention Center, they have a policy in which they are not allowed to charge someone who's incarcerated or in their custody more for an item than would be reasonably charged at a convenience store in that location. So 7-Eleven, something like that. Those range from about 2.5% to about 4%, depending on the store. So the 5% we thought was higher than the average markup that you would find at either a convenience store or a regular grocery store, and falls in line with what we see as a state's best practice, which is how Clark County Detention Center handles its commissary.
And then my other question has to do in that same section with the exclusive contracts. Have you found in other states that they have additional like that competition? And do you know why? Maybe this is a question for the department on why we only have an exclusive contract for supplying commissary?
Nick Sheepback for the record. Why we have an exclusive contract, I do not know. I do know that most other states provide multiple vendors, especially for the package programs. In California, you have multiple. In New Mexico, you have multiple. And what this does is it creates competition within the system and naturally drives down prices. When there's an exclusive contract with a vendor, we see higher prices. We currently contract with Keefe, and I do believe this is changing, but we have been able to compare Keefe's pricing in Nevada to states that Keefe is in where there is competition, and their wholesale pricing is lower in those states where there are other options to buy from. So we believe that ending monopoly contracts within the Nevada Department of Corrections would let the free hand of the market drive down cost for incarcerated individuals and likely the state.
And my last question is, what section is it that talks about not having to pay for the housing? You know, I know we heard this previously, and I think it was in a budget committee, or maybe it was in this committee, I don't remember, about how those individuals that were actually doing work were having to pay for their room and board, as opposed to someone who wasn't working and wasn't contributing, not having to pay for their room and board. So I'm sorry, where was that located in?
Nick Sheepek, for the record, that is section 8.4 sub A sub 3.
Okay, I see it there. Okay, thank you.
Yes.
Senator Krasner.
Oh, thank you, Vice Chair. Thank you for your presentation, Mr. Shepak. I did have a question. Let me see. You stated that an inmate cannot be charged for prescription, medical debt, accident, self-harm. They can be charged for an inmate harming another. Is that debt discharged when the inmate leaves the prison? If the inmate harms another and that's still on the books, is that debt discharged, please?
Thank you for the question, Nick Sheepek, for the record. So I believe as written, if that is medical debt, that would be discharged. I'd be willing to absolutely have that conversation. However, if there is restitution owed to the individual who harm was caused, that debt would not be discharged.
So that kind of goes against, I mean, I appreciate the part that you have restitution in there for victims. But if the inmate can harm another inmate or a guard or correctional officer, and then when they leave, all that debt is discharged, it's, I don't know, it doesn't seem right.
Nick Sheepek, for the record, you bring up a great point, Senator, and we would be open to an amendment to ensure that an individual who causes harm to another individual is on the hook, more or less, for that debt.
Okay, thank you very much.
If I could just weigh in, Melanie Scheibel, Senate District 9, and I totally agree, and I think that Nick touched on it. It would have to do with how that debt is categorized, if it is lumped into medical debt or if it's actually recognized as a restitution payment. And so we could probably craft some language to make sure that if you cause harm to another person, you owe that person restitution and ensure that it receives the protections of any owed restitution, which follows you even after you leave the facility.
Madam Vice Chair, I didn't hear, did you give me a go-ahead?
No. Senator Hansen.
Thank you. Nick, you're sounding kind of capitalistic today, you know. The only problem with that is, how do you have a competitive environment in a prison setting? I mean, if we crack down on any for-profit aspect of it, is there, you know, obviously I agree with the whole concept of what you're bringing up. They're getting gouged. But in the absence of a for-profit company, in other states, do they actually have a state-run commissary, or will we have no commissary at all if we eliminate the private sector aspect?
Nick Sheepek, for the record, this bill would not touch the profits of the private companies that contract. So the way that the Nevada Department of Corrections works commissary now is, and I could provide the price list. Keefe has a price list. It is a bulk item price list. They order 100 soups at a time. Then NDOC chooses to mark those up on their end. The state does. So regardless of what their markup is, Keefe makes the same amount of money. This would make no less money for the for-profit companies that are coming in and contracting. So the incentive for them to still work with the state would not change. It's just that we would not be running this $14 million, what appears to be somewhat of a slush fund within the department. We would pare that down to something where we're still meeting the needs. However, we are not overcharging everyone, but it wouldn't affect the private companies.
Okay, well, actually, the reason I bring it up isn't just that, too, because, you know, the bigger issue here is I think the Department of Corrections over the years have developed programs because, frankly, the legislature's underfunded their programs. So we're in effect passing on to them an underfunded budget, and then to try to figure out some way to compensate. I'm hoping there aren't people in the prisons that are actually personally profiting from markups on 100 uniforms you mentioned, for example. But I think as I listen to this, I'm going, I can kind of see what's happened over the years, and that is they're trying to come up with some mechanism to fund what we at the legislature have failed to do. Now, that's my theory of you guys as you've looked at this, you know, how much of this problem is actually caused by improper funding on our end versus potential gouging by companies or even employees perhaps working within the Department of Corrections?
Nick Shebeck, for the record, I think you've hit the nail on the head. I think we got here through, it's a concept of like death by a million paper cuts. We've made small budgetary decisions session after session after session that have ballooned into something that is extremely onerous and painful for families. And our goal with this is to work with finance to figure out if we can get those positions funded, right? Where can we add some money into the Nevada Department of Correction budget to alleviate some of this? If we work session this, I can promise you that I will work to ensure that both the Nevada Department of Correction keeps its budget and its staff, that the state picks up a little bit more of the tab, and that the families find some of the relief they need. But you're 100% correct. These laws and policies were created in response to a lack of funding by this body.
Okay, well, I just want to kind of get to the record because, I don't want to hold the Department of Correction. It's almost sounding like, you got some exceptionally greedy capitalists running the program, and they figure out they have this target market where they can just squeeze the heck out of them because they had nowhere else to go, when in reality they've been forced to kind of juggle things around to try to balance improper funding on our end. So just want to make sure that we're not, picking on the wrong guys here, frankly. So, and I hope you're not trying to work session it today because you're running out of committee here pretty quick. Get an exemption real fast. With that, Madam Chair, I was kind of looking forward to have a discussion with you. I was just kind of enjoying this situation. Thank you, Madam Vice Chair.
Next week. No additional questions? Everybody ready for testimony? Okay, we're going to start in Las Vegas for testimony and support. Senate Bill 416, come on up to the table.
Hello, I am Destiny Rich, and I was formerly incarcerated at FMWCC. Majority of inmates have to depend on their families to help support them. I depended on the $100 I received a month. Some inmates depended on the wages of work of $10 a month to help them get by. Commissary increased over 4 times in 2022 while I was incarcerated. Those who were working at the prison, their pay did not increase 1 time, but the hygiene products did several times. These increases were as much as $10 jump on tampons. Tampons went from $7 to $19. A bag of coffee went from $12 to $16. We just found out on Wednesday morning that hygiene products are no longer subjected to a markup, which is a huge positive impact. It would be amazing to see no markups on the other items on commissary, such as clothing, which includes underwears and bras and food. When these prices increase, it impacts us because we don't have a choice to buy at another store. These items that are marked up are items that we need to live in this environment. For example, to maintain my mental health and physical health, I need to work out. I needed the proper attire to work out. The New Balances shoes that I was finally able to afford after a couple months of saving for it, it cost $90 on commissary. And those same New Balances that cost $90 on commissary would be advertised in the mail at a store for more than half the price. These prices have no limitations to those who are limited on financial support from loved ones. Before I close this, I would like to share with you my medical experience. In the month of September, I was doing my daily work of picking up chairs, and I lifted a chair too far over my shoulders. Then my back went out. I could not walk. I was in need of urgent care but refused because of the price of the man down. The man down is over $150. Until this day, I have issues with my back. Overpriced medical fees in the Nevada Department of Corrections leads me to put my physical health last. I am here to support SB 416. Thank you for your time.
Good afternoon. My name is Ashley Gaddis, Gaddis. I really hate reading these, but because I do have the experience and it is personal, but I have to stay on track. Okay, so I am formerly incarcerated and I'm here to support SB 416. The impact that this bill could have for the currently incarcerated and their families is huge. I have been directly impacted by the outrageous pricing of store items that are offered within the NDOC. I was often left with the choice to either buy additional food, hygiene products, decent clothing, use of the phone, or go to medical for any type of complaint. Rarely could I do any combination of these within a month period, and always leaving me a choice of one or the other. I have no idea where the concept came from that incarcerated people are rich, when the truth is most have lost everything prior to prison and continue to have limited to no financial support. I worked several institutional jobs while incarcerated, to include NDF, Nevada Division of Forestry. I was paid very minimum for extensive manual labor, 8 hours a day. My pay would average $33 a month. Once deductions were made from room and board, a victim fund, and other miscellaneous fees, I would net approximately $21. That amount would be further reduced if I needed to go to medical and pay the $8, reducing my pay now to $13. $13 a month. Institutional jobs are some people's only source of income. The biggest concern I have here is profit over prisoners. It just doesn't make sense. I'd like to share the mental impact briefly with you of not being able to provide for myself while being in one of the darkest times of my life. The high cost of basic needs and medical concerns kept me in a constant struggle with myself and self-worth. I would often ask myself, what should my self-worth look like in a place like this? Often coming up with an answer such as, well, you committed a crime, you deserve this. When no, that's horrible. That is absolutely not acceptable. After a couple years with these negative thoughts and ideas, my thinking finally changed, and I realized that being in prison does not mean that I have to lose my dignity and self-worth. Luckily, this is how I can stand before you today and ask for support for those who are currently experiencing these same challenges that I experienced. I know I'm not alone with those feelings, and I know that passing this bill is the right thing to do and in the right direction. How can a person focus on the necessary personal changes that they need to make to be in the best person they need upon leaving when it has been nothing but a struggle inside prison? There are plenty of reasons why people worry in prison: to not have to worry about sufficient food, adequate hygiene products, or what kind of illness they might have. It's just plain cruel. I know that there is a way to make this work for everyone. Please understand and know that the cost of incarceration is real and the results are real, leaving families in debt while trying to support themselves and an incarcerated person in Nevada. Thank you for your time and consideration.
Hi, y'all. This is Susan Profit. I'm the Vice President of the Nevada Republican Club. And I have a couple of suggestions for you that might help. I do approve what you're doing. These ladies should not have to pay $10 for one tampon. This is highway robbery. And I don't understand why Charles Daniels has not been held accountable financially and criminally for what he did. All right. I really think maybe you ought to go after him, do a little bit more of an audit, see who he was paying off, and how many people are in this little ring of criminals, because, you know, this happens in prisons more often than we'd like to admit. And I really think these people deserve to be repaid. Make it retroactive. If he was offering Sisolak $1 million, wasn't he? So $1 million, give it back to these people. They need it. And if not done already, I suggest that you hire a purchasing agent that is responsible for doing a yearly cost analysis on everything in the commissary, and make this audit and report available to whoever would be overseeing it, like, say, the governor. I don't know how it's being done, prison oversight now, but if they were allowed to get away with this and only reprimanded him year after year after year, I suspect someone was getting paid off, and you need to find out who that is, and good luck with it. These gals need some help. Thank you.
Good afternoon. My name is Margot Tello. That's Margoth, last name Tello. I am a member of this community and here to support SB 416. We need to provide individuals more than $25 at discharge. I've been working in the criminal justice field for over 5 years, and I've seen the effect the lack of financial stability and crippling debt has on individuals. That, plus the difficulty formerly incarcerated individuals have in finding employment due to their criminal history, is not setting up for success. This leads people to continue walking through the revolving door that is incarceration. If our goal truly is to keep our community safe and to help individuals who have served their time be successfully integrated back into the community, I ask that the committee pass this bill. Thank you.
My name is Sonia Williams, SONYAWILLIAMS. On December 13th, 2021, my loved one died in High Desert State Prison after a 7-month battle with kidney and colon cancer. After he died, everybody I talked to at NDOC kept telling me, NDOC will pay for his cremation. NDOC, we'll pay for it. And I refused to let him go back to be in the control of the prison anymore after he died. So I took on the costs. Let me tell you what those costs were. A cardboard cremation container, which is mandatory, was $175. The direct cremation, which means that there was no funeral services, no obituary, and no viewing, was $1,200. A copy of a death certificate, which is required by DOC to obtain his personal property, was $39. There's a state regulatory fee of $10. A temporary urn, which consists of a 6 by 8 by 4-inch plastic box with a name tag on the outside of it, was $50. And then the tax was like $15. And then I also had to obtain a copy of his medical records in order to see what his last moments were like, which was $367.80. So a total of $1,856.47, and this was a week before Christmas. I can't even imagine what NDOC would have charged me with their normal 65%, 66% markup, a total about a little over $3,000. Oh my gosh, so sorry. I lost my place. The fee, I imagine NDOC obtains funds from the state in order to deal with deaths of inmates. However, in my case, Eric had been approved for compassionate release, but was delayed over and over again by NDOC and ended up dying in a Seamount cell. Return Strong helped me give my daughter a Christmas that year, and 2 months after he died on Valentine's Day, my daughter was finally able to bring home her dad. I support SB 416. Thank you.
Carson.
My name is Jody Hocking, JODIHLCKING, and I'm the founder and executive director of Return Strong. Those are my families, that just a few of them. I want you to understand that really we could have filled both of these rooms. We're giving you guys a break on this one. But Senator Hansen said something earlier I think is really like the core of, again, what we're fighting is the tip of the iceberg and the root of the problem. We have been for 2 years blaming NDOC, and it wasn't until we saw the exclusive contract and we understood what all started to really understand the difference in what was happening and realize that in some ways they're getting pinched in the middle of this. But what we're doing as a state is choosing to pass the cost of incarceration on to families. Sonia shouldn't have been paying for her daughter's father's body. That's not what should be happening, right? And I think making sure that people understand day in, day out that those costs are being paid from somewhere. From single moms who have lost the income when their husband is now incarcerated, who are now trying to meet all of those bills by themselves and really like take on that responsibility, are now also being asked to supplement the state choosing incarceration as our main means of social control. And so I just want to just reiterate that, like, we have to always be looking at where is the root of the problem. The root of the problem is funding, and where does that funding come from? Should we be paying visiting officers so that we can see our loved ones? I think it's not visitation, it's like law library and some other positions. But at the end of the day, there are tons of emails that were sent to you with people's stories, and I hope that you take the time to hear some of them, because like Sonia and Ashley and Destiny, and there are a million of us that could, or about 8,000 of us for sure, that could show up and tell the stories of how we're impacted by the cost of incarceration. It's been amazing. I do also want to give a shout out about the 0%, like taking the mark off of hygiene. I got a call from one of our organizers at Lovelock this morning, and he said there were about 600 people that were there just like literally going crazy at the difference. When you look at like Suave shampoo, which I'm not even sure anybody buys Suave shampoo anymore, but they were charging, it was $9 and it's down to $4. Toothbrushes, soups, like they're not soups, toothbrushes, hair grease, like it didn't matter what it was, everything now has no markup, and the difference has been tremendous. People are like taking a breath of fresh air and like relief. But this bill is how we make sure that it's not just hygiene. Like that's one step. We have to look at the rest of it. So thank you for your time and for 2 years of listening to us complain. I appreciate you.
Thank you, Madam Vice Chair. John Pure from the Clark County Public Defender's Office. We support this measure. Thank you.
Good afternoon, Vice Chair Erica Roth with the Washoe County Public Defender's Office. We urge your support. Thank you.
BPS phones, please.
If you would like to testify in support of SB 416, please press *9 to take your place in the queue.
Tanya Brown, Advocates for the Inmates and the Innocent. I want to personally thank everyone who was involved in getting this bill forward. This is something that we have struggled with, the advocates, for decades, and currently this is what the new advocates, the Return Strong, have done a wonderful job with this. And so anyway, we strongly support this bill. Anything that could help lessen the financial strain on the backs of the families and the inmates is fantastic. Thank you, and have a wonderful day.
Hi, my name is Amelia Booth. I support the bill, and I won't go into detail, but I do spend about $550 every month to support my person. And if I were a single mom, or if I were still raising my children, there's no way that I could make that work at all. And I just really have an issue with us, the loved ones who are already paying a huge price of having our person locked up, that we are a source of revenue. So that's all I have to say. Thank you.
If you're waiting to testify in support, please press *6 to unmute.
Caller with the last three digits is 025. You are unmuted and may begin.
Hello, my name is Nicole Williams, Williams. I am an activist, volunteer, and board member with Return Strong, as well as an impacted family member who has a loved one that's incarcerated. I handle all of the incoming mail and can tell you that 1 of every 3 letters that we receive has to do with prices of commissary and packages, small food portions, and lack of medical care or receiving prescriptions. I'm financially impacted because my husband made a poor decision, and it's hard to budget my bills and responsibilities out here, but also ensure his well-being in there. So I'm just going to keep this short and let you know that I fully support this bill. Thank you.
There are no remaining callers testifying in support.
Opposition, Carson. Opposition, Las Vegas. Opposition phones, please.
If you would like to testify in opposition for SB 416, please press *9 to take your place in the queue. There are no callers testifying in opposition.
Neutral, Carson.
Thank you, James Arenda. For the record, Nevada Department of Corrections Director. Today I have here with me our Chief of Inmate Services, Adrian Monroe, just in case there's any specific money questions. There are some concerns that I do have with the language in this that I just want to make sure everyone's aware of. First, first to Senator Wynn, just to clarify some of the questions that she had related to the screen that's up there. That's not 21.5% of the population. That's 21.5% of the 276 that responded. So it's actually 59 of the offenders out of 10,000, and the other one's 27.6 offenders out of 10,000. Not to downplay the issues, just wanted to clarify that screen. When you go to Section 3, my concern about limits, I don't have a problem with cost limits, but you have to have a limit on the quantity because the offenders can't have more than certain cubic feet in the cell covered due to fire laws and fire marshal concerns for the fire code. Like I said, the quantity isn't a problem with mine, it's the space. The other piece of we talk about in Section 4, having those accounts. I just want to make sure it's clear that the Nevada Department of, Nevada Department of Correction can still have access to remove involuntarily for victim restitutions and also for child support and Megan's Law requirements, if it plays a factor, just to make sure it's clear. I'll go to Section 6 on who actually pays the current costs that are related in this. When you're talking about any of the costs that are deducted from the money to repay the cost of the medical, it's somebody pays the cost, which I know was brought up here today. If it's not done by this means, that there has to be some other funding source to be able to pay for this. Going into Section 7, well, again, I just want to stress that we do not pay for the hygiene items. Starting about 2 weeks ago, we do not pay on markup. We do not let the inmates pay for markup now on the hygiene items. I think the biggest issues that we see in the department is what we provide for the free items. Probably aren't the quantity or quality that everybody's looking for, which I think needs to be reviewed. We do have 4 vendors where there is not a sole vendor for Keefe. Keefe is our primary contract vendor, and then we have 3 additional vendors for items that are large stocked items or items that are not provided by Keefe. So even though there's one contract provider by Keefe, there's also 3 other additional vendors that we can select from. I will go to Section 9. Again, on when you talk about this is the same thing on some that the sources of pay and monetary amounts have to come from somewhere. Somebody will have to pay for these services somehow. Section 8, we do have, just so everybody's aware, we do give up to $100 gate money, it's called, for those that are released into the community. Also, when you're talking about the money or that goes back to the offender when they leave, we do provide a debit card. The debit card, which the fees and all that could be provided by our Chief of Inmate Services, but it's really, they don't get charged for the card, they get really charged for if they don't use it. And anything, it's up to cards up to $9,000. Anything over that, they get a check for. We can provide a check to the offender as long as we get a long enough notice and we can send, that they have an address that we can send it to. So those are the other issues of the concern which our Chief of Inmate Services can actually go over. I will also mention that what was the other one? That the markup items that we do in commissary, it also needs to be clear, we have what's called revolving funds. Those markup items are paying for the cost for not just staffing. It also pays the cost for the storage. It also pays cost for the travel. It also pays cost for deliveries. And all those items all come into the revolving funds that actually pay for the services. So I just want to make it clear, it wasn't just these markups don't only pay for the staff to provide services. And the staff to provide services is not just for commissary items and commissary staff. It's programs, it's support services, it's substance use disorder programming, it's substance use disorder staffing that comes all with it. But anyway, that's all I have. If there's any questions, we can provide some answers, especially from our Chief of Inmate Services that may have what you're looking for. Thank you.
Thank you, Vice Chair. One thing I want to make sure is that, we're not holding you accountable for this. You know what I mean? You just came here. I see Nick shaking his head in the background. I mean, we want to work with you to resolve a legitimate problem, it looks like. Your experience, though, from Connecticut, you mentioned, what is it funding on the Nevada side versus, say, Connecticut, or your other experiences in other areas? I mean, the impression I get is that you guys over a period of years have developed some internal mechanisms to make up for the failure of the Nevada Legislature to properly fund the Department of Corrections. But since you've been in other states, how do they do it?
So James Arenda, for the record, both Connecticut and New York, the funds are paid by the taxpayers. So when you have up to 90 staff that our funds pay for, those up to 90 are actually paid by the taxpayers in the state of New York and Connecticut.
Okay, good. Well, I see, Nick, you got a job to do, bud, because now you get to go to fiscal. I mean, I'm assuming we get it out of committee today. You know, I want to definitely help in any way I can, but I think, you know, I want to make sure the staff doesn't realizes we're not looking at you guys and saying you're a bunch of crooks and it's been exposed. And one other thing, now, feminine hygiene products. You guys supply free ones, but if they want the better quality ones, is that the testimony? If they want the better stuff, they got to go and buy them at the commissary? Is that what I was wondering? Is I'm thinking, okay, if they don't get them from the commissary, I mean, that, you know, where the heck they get them?
So James Arenda, for the record, yes, they will get them. It's not really what they want, but we do, anyone, first of all, every single offender upon intake to the department gets a care package, and every hygiene item that we could provide is in those packages. Indigent offenders get those free as long as they're indigent. However, the issues that I've come across is the type of the item. If most people probably would never even want to have those items. Some of them, especially when they mention the feminine napkins, they probably are probably not even ones that you would want to buy in a dollar store.
Okay. And last question, if I could. When a prisoner is convicted, often there is a restitution dollar amount that they're expected to pay. Do you guys have, is there a responsibility on the part of you guys to help collect that, or is there?
So James Arenda, for the record, yes, we collect the restitution while they're incarcerated, and when they discharge, we collect the restitution when they are leaving before they get their debit card or check.
Okay, and then that money is actually put on the account for the paying back whatever, you know, if they did something wrong, the judge in this sentencing said, you know, you're going to pay back restitution to the victim of $10,000, and that is then used to offset that, and then what, it's reported back to the court system and they enter parole, or how does that? I'm just kind of curious about the process.
So James Arenda, for the record, that is, but the exact who it goes to, I'm not sure. But it's specified when they leave where those monies are going to, whether it's going through the Megan's Law restitution or whether it's a court-ordered restitution, whether it's child support. We have those for every offender when they're discharging, what they actually owe and how much we take. We take it, and that could go to 3 different actually accounts or to those areas. And yes, and parole is notified of what was actually taken out if they're going on parole. And
Okay.
where.
And last thought, you know, we're so delighted to get you back. One thing I don't want is to have you feeling like the whole world's coming down on your shoulders and you say, hell with Nevada, I'm going to go to a state where at least they fund the damn prison system correctly. So thanks for being here, and I'm hoping we can get this resolved. Thanks, Madam Vice Chair.
Thank you, Vice Chair. Thank you for your presentation, Director Zorinda. So, you know, we heard the presentation from the presenters, and now we're hearing that you do have some concerns and things that you want to clarify. Because today is the last day to hear bills, I'm wondering if you are interested in working together with the presenters on amending language that would be agreeable to all parties.
So James Arenda, for the record, yes, and I mentioned it before, not in front of you, but I mentioned it before, we need to work on amendments that are actually something that of voicing my concerns. And one of them that I didn't mention was about the food. They are correct, but the food that we have, that we provide the offenders is monitored by the state, not by corrections, by the state medical department, the health department. They have a dietitian that monitors our food. They provide the doctor, the state medical doctor provides a report quarterly to the Board of Prisons on the food, and a lot of it is dictated by the U.S. Supreme Court. They, in the state of Nevada, which I think is, I believe at the time, I don't know about today, but this is going back to 3 years ago, was the only state that the U.S. Supreme Court mandated a maximum of 2,200 milligrams of sodium quantity in each food meal. When you look at that, that's like a bag of potato chips. So I think that's where a lot of the issues started coming up, because you're putting less sodium in the food, which is going to be less quantity of those foods that anyone likes, and the tastes are not going to be pleasant. So I think a lot of that's where you started seeing a lot of the food problems come in, even the food strikes that were coming up from the offenders was really because of the results of the U.S. Supreme Court.
Thank you.
Neutral Las Vegas. Neutral phone, please.
If you would like to testify in neutral for SB 416, please press star 9 to take your place in the queue. We have no callers testifying in neutral.
All right, thank you, Vice Chair. I do have a couple things that I want to say, and I'm going to try to do them in order so I don't forget. First of all, I'd like to address Jody Hawking on the record, and how dare you call what you've been doing complaining. You are an advocate and an organizer and a better policymaker than some of the elected officials in this building. More effective anyway. So I think that, we are all, the state is better because Return Strong is here. And I think that I've been so happy to have Senator Hansen with his questions today, really elucidating the need for this bill, which is to say that, we pick on the Department of Corrections a lot, but sometimes there are problems that we as the legislature have to solve. And the Department of Corrections can't do it, not only without, advocates behind them, without partners behind them, but without action from the legislature. So literally without a bill, this can't be done. And so that's why it's so important that we pass this bill today. I don't normally get to say that, but this is the deadline day. And I think we're very lucky that all of us have been serving in this body for, more than a session. We've all been here for a few sessions and gotten to know the Fines and Fees Justice Center, Return Strong, Director Zarenda. And this is one of those cases where I feel very confident looking at the team that we've assembled that we will be able to continue to work on language, work on a bill, and work this through the finance process. I think that Nick has, Mr. Shepak, has already said what I'm going to say, which is that we're not trying to hide the ball here and pretend that we're going to get a $12 million general fund allocation and solve the problem tomorrow. But we need the vehicle. We need the bill to go to finance to continue to have those conversations with Senators Wynn and Harris, who are, very adept legislators who sit on that budget subcommittee to look at the numbers and say, which parts can we do? Is it section 1? Is it section 3? Is it section 8? Is it section 9, subsection B? But we can't even start that conversation. We have started the conversation. And the way to keep it moving is to pass this bill through committee today, take it to the Senate Finance in the figurative tomorrow, and continue to work on this issue and continue to bring the best and the brightest and the important stakeholders to the table to make the right choices moving forward. The other thing that I promised I would say was that we also had some callers in support. As you probably noticed, there was something weird going on with the phones. They have all submitted their testimony via email online, but there were 7 people who wanted to call in and express their support. They are understanding of our deadline, and so we're not asking to open the lines back up or anything like that. And finally, I just wanted to kind of drive home for those of us who maybe don't have the same kind of exposure to the prison system or a loved one who is incarcerated, the importance of commissary and the importance of the store. I think, when we see it in movies or on TV, it looks like the corner convenience store, and like that buying food from the commissary might be a treat, or it might be something to pass the time, and it might be easy. But the reality is that for a lot of incarcerated people, it's not really optional to utilize the commissary, because like you heard today, a lot of them are still hungry after dinner, and that's the only way that they can get more food. They are very limited in the hygiene products that they get. Not only, we're not talking about luxury products versus dollar store products. We're talking about sheer quantities. I'm pretty sure that people who menstruate are given 18 pads to cover them through their entire cycle. So if you have a cycle that is 6 days long, that's 3 pads per day. And for a lot of people, that's just not sufficient. And so we're not talking about going to the commissary to get a better brand name because it's more comfortable, but we're talking about supplementing what we have funded the Department of Corrections to provide for free, going back to our previous conversations. It's not that the Department of Corrections is, purposely trying to deprive people of hygiene items, and they have reduced the markup so that more people have better access to hygiene items. But we're talking about, imagine if you were traveling and you forgot your hygiene kit, you forgot your toiletries, and there was either nowhere to go or one place to go, and you had to pay what you had to pay to get those items. That's what we're talking about. We're not talking about people who are sitting at home with options available to them, deciding whether or not they want an extra soup today. We're talking about people who are hungry, and the only thing they can afford and the only place that they can buy it is at the commissary. So with that, I will turn it over to my co-presenters to make their closing remarks.
Thank you, Vice Chair. Thank you, everyone. Nick Shepak, State Deputy Director, Finance and Fees Justice Center. Don't know if I can say it any better than that. I can just guarantee that if we move this, I will work with all interested parties. We will make sure that the department's concerns are addressed, and we deeply believe in this, and you have my full dedication. Plus, any excuse to meet the director at the bank to work on an amendment is always most welcome. I also want to thank and congratulate our intern, Katie Brandon, on her first ever presentation to the Nevada State Legislature. Thank you all today for letting us be the cherry on top of the deadline day.
Hearing closed.
All right. Thank you, everybody, for sticking with us. And I have my whole committee back now, which means that it is the perfect time to accept a motion. All right. We have a motion from Senator Nguyen. Do pass? Yes. Okay. And a second from Vice Chair Harris. Any discussion on the motion? Senator Hansen.
Thanks. I enjoyed the presentation. I just want to make sure that, since it is deadline day, but I want to make sure that there's a complete commitment to get this thing resolved before. I don't want to go on the floor and find out that we couldn't work it out and then have to vote no on it. But I'm definitely going to vote now in favor of it. I think it's definitely needed. But I'm a little uncomfortable doing it before we've amended it or find out if we can work out a deal here. And of course, all of us have to recognize that this does need, if we're going to go forward with this in a significant way, we got to get some significant funding from the legislature. Thanks, Madam Chair.
Thank you. Senator Krasner.
Thank you, Chair. I really appreciate the presentation and Director Zorinda's input. And I also feel a little uncomfortable voting on a bill when I don't get to see the amendment. But I understand we're under a tight deadline, and so I appreciate the fact that all the parties have said they are committed to working together. So I will vote yes out of committee and reserve my right to change my vote prior to floor. Thank you.
All right. Any other discussion on the motion? All right. All those in favor, aye. Aye. Any opposed, nay. Nay from Senator Stone. So with that, the motion to do pass Senate Bill 416 carries, and I will take the floor I'll take the floor statement, although I think it's going to get referred to finance. But that's what we're going to do for now. And with that, we will move into public comment for our meeting today. Anybody wishing to give public comment in person is invited to the front. And I see somebody in Las Vegas. Please go ahead whenever you're ready.
Okay, good afternoon. First of all, I'd like to apologize for something that happened last night. This lady was not with our group, but I'm sure it looked that way, and I do know her. And she spoke out when she shouldn't have and was removed. So I apologize for her. It will never happen when I'm in the room again.
That's okay.
I'd
Can you
like
just
to thank you.
put your name on the record for us?
Susan Profit. I'm the vice president of the Nevada Republican Club. I'm sorry. I've been doing this too often, and I'm sure you agree, and I keep forgetting my name. And I did want to point out one thing that I thought was worthy, and that is Senator Hansen, I don't believe that gentleman who was responsible for all of these overcharges is a greedy capitalist. I think he's a criminal, and I really do encourage you to find out just how many more people are tied into it, because it's not a good thing. And I wish you guys would make sure that Governor Lombardo's education bill is passed as soon as possible. We desperately need these schools fixed, because once you get the schools fixed, we can attract more people to move here and fill in those medical positions that we desperately need. People aren't going to move here unless we have the infrastructure. And one more thing I'd suggest, and that is that when you recruit for the next election, that you do it in a way like a business would do. You know who's on your team now, and you have weaknesses and strengths. So it would be a wonderful thing if you would recruit people to fill in the blanks that you have missing, that have the expertise of building companies, large and small, not just small, and more business people and less government employees, because they don't have the experience of building something from scratch. And independent business people do. And so I'll leave you with that. Have a great weekend.
Thank you so much. I don't see anybody else coming up to give public comment in Las Vegas, so we will go to the phones, please, for public comment.
If you would like to provide public comment, press star 9 to take your place in the queue.
Tanya Brown, TONJA, Advocates for the Inmates and the Innocent. We would like to thank you for the wonderful job you guys have done. These bills are spectacular, especially this last one. I just want to give a brief history of why we'd like to see the Assembly Bill 49 amendment accepted when it comes over. My brother was wrongfully convicted. He spent 21 years in prison for a crime he didn't commit. In 2009, the District Court Judge Brent Adams ordered the District Attorney Dick Gamick to turn over the entire file in his case. So when the file was turned over, all the exculpatory evidence was found hiding in the DA's file, including the handwritten notes of the prosecuting attorney who had withheld all the exculpatory evidence from the defense. And as his attorneys were getting ready to file motions for new trial and bail, he died. He died from lack of medical care. Anyway, 2 years after his death, I hired a private investigator to locate the Sparks PD's prime suspect, Mr. Zarsky. They located him in Utah. Mr. Zarsky wanted to speak with me. I drove to Utah and to hear what he had to say. And then yesterday I spoke about an inmate in Nevada who actually wrote a declaration that would help exonerate an innocent man from a 30-year-old crime or a 20-year-old crime of a murder. And through the Innocence Project, he had been exonerated, thanks to this Nevada inmate who confessed to that crime. And I would just like to add that although my brother has passed away, He did learn the truth prior to it, and I continue to pursue justice for him and to pursue justice for anyone else's family whose loved one has passed away. And I will tell you that the private investigator did interview the suspect, Mr. Zarsky, and he has turned over, and I have been given a declaration from the private investigator. I'm just going to leave it at that. But I wish you all the best. Have a beautiful weekend, and we'll talk to you maybe on Monday. Thank you.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. When I think about dedication to the pursuit of truth and justice, I think of Miss Brown. Often I want to give up in the
We seem to have lost a caller. That concludes all public comment.
All right, thank you. If that caller wants to submit anything in writing, we'll gladly review it, or maybe we will catch her next time. And next week, our schedule will again be a little bit fluid due to the nature of having just passed hundreds of bills out of committee. I do not plan to have a meeting on Monday, so you can expect a meeting canceled agenda to be published soon. And with that, have a great weekend, and we are adjourned.